Garner. This work was selected because of its enduring effect on lawyers who are involved with litigation. Its advice on how to prepare for and effectively present a case is unique, well-crafted, and a must-read for aspiring legal writers. It lives up to its billing as, quote, combining the practical wisdom of an incisive Supreme Court justice with the learning of a renowned writer. We have fashioned this portion of the program around an interview format. Award winners, Justice Scalia and Bryan Garner, join us, and that Bill Press now proceed.
Was he a tough editor, Justice?
Yeah, you know, we see things eye to eye to such a high degree that it was a lot less trouble than you'd think. And you know, come to think of it, I'm in the position of being a joint writer with 8 other people all the time. He was a piece of cake compared to
Who's the best writer of the court today?
Scalia, J. There's no doubt. No. Although, may I just answer this?
Go answer.
I mean, you could be.
Let me have it. Be honest.
Today, I had the honor of presenting to Justice Ginsburg a Lifetime Achievement Award in legal writing. Justice Ginsburg is a wonderful writer and weighs her words very carefully. Last year's winner of the Lifetime Achievement Award from the Scribes organization was Justice Scalia. And they have been the only 2 nominees for years.
Yeah.
So, I think that answers your question.
I think that does answer the question. When you weigh all the different factors that go into presenting a case and winning a case, how important is, Justice, the written brief?
Oh, most people think the written brief is the whole thing. I mean, the usual question I get is, you know, usually with a sneer, how important is oral argument?
I was going to get to that, but starting first things first, maybe.
Yeah, no, it's very important. It's the judge's first exposure to the case, and the judge's first exposure to the lawyer. And if you have a sloppy brief, disorganized brief, and you know, a brief that has grammatical errors, typos that haven't been corrected, right from the outset, you tend to think this is not a very careful lawyer, and that has to color what you think of the later oral presentation. But to save you from asking the next question, okay. Oral presentation is much more important than most people believe. It is true that, you know, I've read at the Supreme Court level a petitioner's brief that is 60 pages long, a respondent's brief that is 60 pages long, a reply brief by the petitioner 40 pages long, often an amicus brief by the United States government, which I will always read, and innumerable other, increasingly in recent years, amici briefs by other people, some of which I'll read. What can this person possibly tell me in half an hour that's going to change my mind from having read all of that stuff, underlined significant passages, and written at best nonsense in the margin? The answer is it doesn't change my mind that often. But very often, and this is true of any judge on any court, you go into the oral argument on the knife's edge. It's a close case. And oral argument can make a difference because there are things you can do in oral argument that simply cannot be done in a brief.
Bryan? You want to echo, or you add, or?
There are empirical studies that suggest that fewer than somewhere between 7 and 10% of cases change. The judges' votes change based on oral argument. So the briefs are vastly more important, and that's been long thought to be true by judges everywhere. But there have been empirical studies suggesting that that's the case.
So the Burton awards for legal achievement have been around for 10 years. Can you tell us tonight that you have seen vast improvement in the writing of briefs in the last 10 years? Justice?
I know, but we'll wait for 10 years after our book has been out.
Touche. Bryan, are they across the board getting better, or?
I think we have an intractable problem, which is that every generation of lawyers has to learn to write. And when I say write, I mean really write. We all learn the rudiments in high school. Actually, that's not even true. A lot of people don't learn the rudiments in high school. But basic writing skills, very rudimentary writing skills, you might say, every lawyer is expected to have. When Justice Scalia and I talk about writing, we're talking about writing at a professional level. I mean, really knowing your stuff as a writer. And that is, it's a difficult problem because every generation has to learn it anew. And it requires a lot of experience and a lot of hard work, which means it takes a lot of time for an individual to master the skill. I think we're trying to bring back into the mainstream the idea that most people, who enter the top law schools, are simply not prepared to write at the high level that we're talking about, professional writing. And so if you encourage more people to, very talented lawyers, the types of lawyers who might get federal clerkships and even Supreme Court clerkships, to see themselves at the beginning of an apprenticeship that may take a decade or so, then I think that's the right perspective.
When he talks about professional writing, I think he means professional writing and not professional legal writing. I don't think there's any such thing as legal writing. I think there's good writing and there's bad writing. And some of the worst legal writing is attributable to the fact that the writer is trying to sound like a lawyer instead of just trying to make clear the point that he's presenting.
You also talk in the book about working at it, right? Reading and learning your vocabulary and building your vocabulary and really working at it all life long, correct?
It is a lifelong enterprise, and part of the advice we give, and we give it through the mouth of, I guess it's Frank Easterbrook, who put it more pithily than anybody else could. But he says the problem with most legal writers is that they read nothing but court opinions and legal briefs. I mean, that will absolutely ruin you. Court opinions are not there because they're well written or even necessarily because they're well reasoned. They're just there because they're authoritative. And if you learn your writing style from reading court opinions, you're going to have a lousy writing style. So you should read good literature from all fields and learn how to express yourself intelligently and coherently.
And so legal education is a big part of the problem because all that even the talented writers are reading happens to be judicial opinions that are often very poorly written. So I encourage lawyers to read the best nonfiction of our day. And I think of The Economist and The New Yorker and The Atlantic Monthly and Harper's. And
so they won't say stuff like the instant case. They won't, what is that, like instant coffee or what? No, nobody anywhere else in the country refers to the present case or the case before us as the instant case. But it's fancy legal language, so let's use it. No, and it's stupid. Really stupid.